Good. We can see you, Tom.
Great.
How is Chicago?
Hi. It's very good. Peaceful this week. We have some protests going on my block, actually, but that's relatively minor.
I think we're here now. We can start off.
All right, Valentine, we're broadcasting to our participants in 3, 2, 1.
Good day and welcome to today's webinar, which is part of the Law Society of Kenya Discourse series, which is a set of high-level discussions on social legal issues and current affairs. I'm your host, Valentine Khaminwa of Khaminwa Advocates, and today's discussion will be on a research paper titled Transformation into and Endurance of a Hybrid Constitution in Kenya. The format of today's discussion will be an overview of the paper by its author, Mr. Duncan Okubaso, plus a 10 to 15-minute commentary by each one of our distinguished panelists. Members of the audience may send in their questions and views and queries via the chat icon on the Zoom platform. With this, it is our unalloyed privilege to introduce today's distinguished speakers, who are Duncan Okubasu, who's a lecturer of public law at Moi University and a PhD candidate at the University of Utrecht in the Netherlands. We will also have our first commentary from Professor Mark Tushnet, a William Nelson Cromwell Professor of Law Emeritus at Harvard Law School. Our third commentary will come from Honorable Justice Kathurima Mbote of the Court of Appeal in Kenya, also Director of the Judicial Training Institute here in Kenya. Fourthly, it's our profound privilege to also introduce Dr. Tom Daly of the University of Melbourne School of Government and Edinburgh Law School. We will also have comments from Professor Patricia Mbote, Professor at the University of Nairobi. And sixth, we will also have a commentary and input from Professor Tom Ginsberg, who's a Leo Spitz Professor of International Law and Professor of Political Science at the University of Chicago. So without further ado, because we only have 2 hours, I'm going to hand it over to our author, Mr. Duncan Okubasu. Please, can you give us an overview of your paper and its perspective? Thank you.
Thank you very much, Valentine. As Valentine has observed, the paper that I want to give an overview of is titled The Transformation into and Endurance of a Hybrid Real Constitution in Kenya. This paper is a chapter of a PhD dissertation that is at its near end, that is about change and stability of what I call the real constitution in sub-Saharan Africa. Now, the research in general addresses inter alia the stubborn endurance of authoritarian constitutionalism in the region, as well as the question why ostensible commitment to liberal and democratic constitutionalism in the continent has not translated into democracy on the ground, hence the subject matter, the real constitution. Now, by definition, the real constitution is essentially the de facto norms in the constitutional order that explain how power is acquired, used, and distributed. So that this entails both the written aspects of the descriptive constitution, as well as the unwritten aspects of the descriptive constitution. And by descriptive constitution, I don't mean the written constitution, but the constitution that can be empirically detected as producing a particular constitutional effect in a constitutional order. So that this would entail the enforced aspects of the text itself. It would entail conventions to the extent that they are also enforced. It would include informal powers, men behind the scenes, and other unwritten conventions that also play a role in shaping the conditions of the body polity. Now, an assumption that underlies my research is that there's a correspondence between the conditions of the body polity on the one part and the nature of the elements that produce that effect. That is to say, that where you see a society is democratic, then it means that its underlying real constitution is democratic. And if it's authoritarian, then for sure, the assumption that underlies my research is that the real constitution is also authoritarian. Now, I have theorized under my second chapter that when you look at political systems, they can be disaggregated into three broad, they can be said to have three broad constitutions. That means a democratic real constitution, a hybrid real constitution, and an authoritarian real constitution. My idea of a hybrid real constitution is, I think, Professor Mark Tushnet's work on authoritarian constitutionalism in Singapore. Now, prior to the third wave of democratization, which took place around 1989, most countries in Africa had overwhelmingly authoritarian real constitutions. As a matter of fact, it's only in Somalia that power was exchanged from one group of people to another through an election since independence. Now, at the inception of the third wave, which basically started, I think, in the 1970s in Portugal and then found its way in the late 1980s in Africa, many constitutional regimes suffered from a very serious shock. Regimes started collapsing and democracy started to reestablish itself in the region. And I argue that at that time, many real constitutions began to change from authoritarianism to whichever other form. And the case that I make subsequently is that when you study all the most African countries, if not all of them, you realize that different countries attained different transitional outcomes. So that a few of them turned into democratic countries with democratic real constitutions. Some of them turned into hybrid countries with hybrid constitutions, while some of them remained with the overwhelmingly authoritarian constitutions that they had. But that is not to say that that certain aspects of those countries' real constitutions were not interfered with. So Kenya is one of the countries that I consider to have migrated from an authoritarian constitution to a hybrid constitution. And I'm using the statistics of Freedom House to tell whether a country is either having an authoritarian constitution or a hybrid constitution or a democratic constitution based on its profiling of a free country, partly free country, and a not free country. So, in my study of the Kenya's constitutional order, I take the view that Kenya's transitional trajectory began from an authoritarian constitution up to around 2002 when it turned into a hybrid constitution. And since that time until today, Kenya has been unable, like Ghana, to move from either a hybrid to democratic constitution-wielding country, nor has it regressed. So that what we have on board now is a hybrid constitution that is consolidating. And the impression that is created by this trajectory is that this hybrid status was in fact maybe the ultimate destination after all. Now, I decided to, as part of my research, to find out why is it that Kenya has not been able to move from a hybrid constitution to a democratic one, in spite of several attempts on the part of political democracy-demanding groups and other actors to push Kenya's constitution into a democratic one on the ground. And these are some of the answers to my questions. One, that there lied a great potential in change of the real constitution through a change to the incumbent power actors, so that One of the reasons why Kenya has been unable to move is because the incumbent power actors have remained somehow the same people. And since we said that the real constitution also consists of informal politics, the networks that support authoritarian connections remained intact by and large. So that I argue that, in fact, in 2002, when Kenya migrated from an authoritarian to hybrid constitution, the only condition that existed at that time was that there was a change to an incumbent power holder, such that if that doesn't happen, like it hasn't happened, then it's unlikely that we will ever move into a democratic constitution. And that is my explanation number one behind the state of affairs that are obtaining. I must say, though, that as I continue the research, the case of Madagascar also destabilized my emergent hypothesis there, because there has been circulation of incumbent leaders, but its real constitution has never changed from a hybrid one to a democratic one. The second case that I make is that Kenya, like other democratic countries on the continent, like South Africa, had strong democracy-demanding groups. And in fact, that the Kenya's 2010 constitution was a product of a very inclusive constitution-making process, so to speak, to the extent that the major political factions became party to it. However, because of frequent co-optation of opposition leaders into government, the strength of democracy-demanding groups as a drive to real constitutional change has also been diluted, so that it's not possible to reap the gains that come with the existence of a strong democracy-demanding group within a polity. Third is that I argue that international actors have played a rather ambivalent role in Kenya's democratic process. In the 1980s, late 1980s, at the peak of the third wave, when most political orders were undergoing serious transformation, the Moi regime that was in power received enormous support from the Margaret Thatcher government and also from the George Bush government, which at that time was fighting Saddam, and Kenya had given out its sea for use. And because of that, even though the US has played, and other powerful countries have played a very great role in fostering real constitutional change, the role that international actors have played has been, as I noted, quite ambivalent, that they have not supported democracy, and sometimes, as I demonstrate in my paper, they have pursued more of peace and political stability, in quotes, in the place of substantive democracy. I also found out that there seems to me to be a remote connection between formal constitutional change and real constitutional change, even when we look at the Kenyan context, in the sense that in the early 1990s, major constitutional changes were effected, which included repeal of a section that had converted Kenya into a de facto, a de jure single-party state. But that repeal alone did not transform Kenya into even a hybrid regime at that time. And also, in 2002, when there was a change of the real constitution from an authoritarian one to a hybrid one, there wasn't a corresponding change of the formal constitution. It occurred without any underlying change of the real constitution. And so that, and even in 2010, when a new constitution was enacted that seemed very progressive, Freedom House rating of Kenya all through 2010 until now is still partly free. So that, for me, suggests that formal change does not have a direct relationship in the Kenyan case with the change of the real constitution. In any case, the case that I argue is that formal change, most of the time, if not all times, follow change of the real constitution. I also argue, lastly, that the institution of judicial review is an important institution in trying to disestablish the elements, particularly the written aspects of the real constitution, like authoritarian legislation that is frequently invoked by governments. However, the institution of judicial review cannot lead into real constitutional change in a rapid way. It will do it, in my view, in a more slow and progressive way, as, for instance, the understanding about the underlying notions of judicial review also change. And so I argue that even with judicial empowerment, the institution of judicial review has only partly tried to push Kenya into a democratic constitution, but it has not succeeded to dislodge it from its hybrid status. I make the case, though, as I finish, that formal change and judicial review have played a very significant role in preventing regression into an authoritarian constitution. And later on, I contrast that with a case like Niger or even Benin. And I finish maybe by noting on a project that Tom Daly is working on. That looking at Kenyan situation, it would seem to me that the existence of a normatively attractive constitution can be a condition to prevent regression into a worse off constitution. So that the Constitution of Kenya 2010 may not be optimally enforced. It might, there might be a gap between the real constitution and the practice, but to a large extent, it provides, it hedges against regression into authoritarianism. And when you look at another case study I did, like Benin, which has just sunk into a hybrid status, I note that perhaps it's the design choices in its constitution that has made it difficult for democracy-demanding groups to stand against pathologies of democracy. So basically, that is the overview of the paper. And as you can see, the case that I am making is that real constitutional change can only be triggered, of course, by endogenic and exogenic forces that may not be part of the text as it is. Valentine, I think that's the overview of the paper. Thank you very much.
Thank you very much, Mr. Okuba. So that's a lot of information to digest, and it's a unique point of view. Professor Tushnet, if you may, please may you comment and give us your views on the contention that there's a disconnect between formal change and our normative hortatory constitution. Please share your comments. Thank you.
Thank you very much. I'm happy to be able to comment on part of this paper. Excuse me. I should begin by noting that I am not a specialist, of course, in in Kenyan constitutional law, Kenyan government, or African development more generally. And my comments are going to focus only on, not on the overall argument about hybrid constitutionalism of Kenya, but on the portion of the paper and the presentation dealing with judicial empowerment. And my comments have, I guess, sort of two components. The first is a skepticism about the ability of the courts, even empowered courts, to do a great deal to push, as the presentation put it, away from the hybrid part of hybrid constitutionalism toward a more fully liberal democratic constitutionalism. And then the second part is something that came up in the presentation that I frankly had not focused on in the paper, which is that empowered courts might have some role in preventing backsliding or retrogression, tendencies embedded in the political system of political actors to try to eliminate the things that make the conflict. Now, as to the first, I should note that, I'll just do it this way. As to the first, the skepticism about the ability to push hard, what I was struck with in the paper was the focus on what Ron Herschel calls mega politics issues for the courts. That is, issues about the qualification or disqualification of major candidates for the presidency, for issues about the conduct of the central campaigns, presidential campaigns, and the like. The theme in the presentation is that the courts didn't do very much with respect to these mega political issues. Now, it seemed to me that that shouldn't have been surprising, that Herschel's case studies of judicial interventions in megapolitics typically, although not always, involve courts that have already established themselves as significant features in the, call it, political constitutional landscape. And when you have a, call it a young court, not yet fully established as a such a participant, it's not surprising to see that it would be reluctant to take on megapolitics issues. Partly because they might, this is sort of overstating motivations and so on, but the judges might be worried about betting on the wrong horse. That is, intervening on one side, which turns out not to have sufficient political power to sustain itself, and then the courts would become discredited when the horse they back actually loses. Seems to me an interesting question whether, and my ignorance of Kenyan constitutional law comes into play here. The interesting question is whether outside of these mega political cases, you can see the courts intervening in constitutional ways, invoking the Constitution, in sort of small scale disputes. My version would be invalidating statutes that aren't really that important to the governing parties, or sort of aggressively interpreting statutes narrowly in ways that have democracy promoting effects, but not directly challenging the governing parties. Again, I don't know whether that's occurred. The second part of this, now to turn to the second part, some of these things that I've talked about just now might be seen as preventing backsliding, or what Levitsky and Ziblatt call, in a certain sense, guardrails to the Constitution, where the governing parties put pressure on the system. The courts are there to say, look, you can't really do that. You got to operate within the existing bounds. We're not going to do much if you operate within those bounds, but as you press them too hard, we will press back. This is a theme among other works, in Sam Zakharov's book, Fragile Democracies. And this is the point I want to make about Kenyan experience. Zakharov does a good job of identifying the possibility that courts might intervene in what I'm calling these non-backsliding ways to prevent backsliding. But his examples are very thin on the ground. As I read the story, most of the time when courts have an opportunity to intervene to prevent backsliding, they actually don't do very much. And so the question for Kenya, and this, as I say, is not as elaborated in the paper that I read as it was mentioned in the presentation, is how effective have the court's interventions been to, how frequent and how effective have they been to prevent what I've been calling backsliding. My summary comment is that it's probably combining a normative and positive observations. Assume, as the paper does and as the presentation did, that the judicial empowerment in Kenya is normatively attractive and not badly designed to achieve a normatively attractive goal. Let's just assume that. The positive observation is that it seems unlikely that a young, not firmly established institution would be able to do much to push the system in the direction of a more liberal democratic order. Second, it might be able to do something to prevent backsliding, although I think the experience around the world is that even empowered courts don't do very much. And then finally, this is something that I've mentioned earlier, and it's not in the paper. It might be strategically interesting or useful to examine how the empowered judges exercise that power in low visibility cases as a way of what political scientists might call accumulating political capital that they might later expend in a mega political case. Okay, those are my comments. Thanks very much.
Thank you very much, Professor Tushnet. So you also posit a lot of the responsibility in mega politics, and you call on the judiciary to intervene and prevent what you term to be backsliding. So with that, we will move on to our next commentary from our Justice Minotti of the Court of Appeal. Thank you.
Thank you. Thank you very much. And I'm grateful for this opportunity to participate in this discussion. I really largely agree with Duncan's approach and arguments. And to me, it looks surprising that we would actually be surprised that we've not been able to transit to a democratic constitutional framework. First and foremost, if we go back to the momentum towards the adoption of the constitution in 2010, if you look at that history, you find a lot of resistance, very, very, very consistent resistance to the idea of the new constitution. Even when it was considered that we needed a new constitution, agreeing alone on the process through which you would get that constitution was a problem. If you look at the various commissions that we've had, the problems that beset the Bomas process, the constitution that went to the referendum in 2005, which was deliberately watered down from the constitution that come out of Bomas, one clearly sees serious contestation of the idea of a change through the constitution. And even if you look at the referendum itself, it isn't like the constitution, the yes votes really carried the day hands down. There was a substantial number of people who voted against the constitution, which will therefore tell you that the idea of resistance would continue long after the constitution came into being. If you again look at the manner in which you've implemented the constitution, it would be interesting, Duncan, if you were to look at some of the draft legislation that was proposed to implement the constitution and the final law that came out from Parliament. A lot of that law, particularly the law touching on integrity and anti-corruption, what was proposed by the commission that was responsible for implementation of the constitution after a lot of public participation, and what eventually came out from Parliament were totally different things, telling you that we had this problem about resistance still to the implementation of the constitution. The point you make about political mobilization about along ethnic lines, I think is a very strong point. And sometimes we really tend to underestimate the strength, the value of that mobilization along ethnic lines. I think, in my view, this is what makes it impossible for civil society itself to be able to have any serious impact. So it's true, it's been very difficult to change the key personalities in our politics. But a lot of time the turnover of members of parliament, the turnover, it's incredible. After every 4 years, almost 60%, 70% of the sitting members of parliament are voted out. And the people who come in somehow, particularly with very new ideas, somehow they never appear to have any kind of impact. Look at the number of people out, who have been elected to the National Assembly, to the Senate from civil society. When outside politics, they have been articulating the same kind of issues we are talking about. But the moment they go there, because they enter parliament from different political parties that are organized ethnically, they are not, people who used to share the same views are not able to articulate the same principles from a common platform. They are sort of swallowed into these political parties, and therefore you see people who previously held the same positions really fighting out there in parliament. And I would think that really I would attribute to this endurance, this mobilization along ethnic lines. Coming to the judiciary, I think to me it would be, granted this kind of resistance that one sees in the entire process, it would be expecting too much to hope that the judiciary itself would be able to propel the country to a full democratic state. It has very obvious limits, as you point out. Most of the times, the courts themselves have to wait to be moved. Sometimes the courts, your criticism is varied. There are situations where the courts really have gone completely off balance. There are other times where they have tried as much as possible. But I think one of what I see clearly missing in your chapter is an examination of the methods that have been used to ensure that also the judiciary is actually not as effective as it would otherwise be, looking at the provisions of the Constitution. There have been so many informal ways of ensuring that the judiciary really is not effective. And I mean, you are aware about this consistent reduction of its budget, right? Parliament votes a certain amount to the judiciary. Halfway through, that amount is reduced. The Constitution provides for the establishment of a judiciary fund. I mean, 10 years down the line, that fund has never been operationalized. It's written there in black and white. There is this contestation about appointment of judges, right? The Constitution has a very, very clear process about how judges have to be appointed, but nobody bothers to follow that process. And therefore you have this situation where many courts like mine, we are short-handed. I mean, for the first time in the history of this country, we've seen a situation actually where courts have closed down. The Court of Appeal in Kisumu has started to close down. In Mombasa and Malindi, in Nyeri, they have closed down because of lack of finances and failure to appoint judges, right? So you have these clear provisions in the Constitution, and side by side, a practice that is completely, totally against what the Constitution says. And as citizens, we are very happy to live with it that way. I do not think really one can expect the judiciary to change much in this kind of scenario. But I would also like you, Duncan, to look at this this practice, which to me looks extremely peculiar. In the analysis about the amendments to the Constitution, that is the Independence Constitution, up to the 26 amendments that were effected to the Constitution. What one sees from the generation of the first generation of our politicians, they somehow want some respect, in quotes, for the Constitution in this sense. When they did not like a provision of the Constitution, they made sure that they amended it. They wanted to be able to say we are acting within the Constitution. If they did something that we thought was autocratic, they would still say it is allowed by the Constitution. But you see, since the 2010 Constitution, nobody appears to worry about being seen to comply with the Constitution. Yeah, if it comes to the question like appointment of judges, you don't even try to say, we do not agree with the Constitution, let us change it, and then we adopt a different method. All that you do is you actually totally ignore what the Constitution is saying. If you are unhappy with the judiciary fund that is created by the Constitution, nobody tries to amend the Constitution to remove the judiciary fund. You just refuse to pass regulations or legislation to operationalize it. And therefore you have this practice that goes side by side with the, unconstitutional practice that is very, very, very comfortable with the provisions of the Constitution that provide extremely otherwise. So I would completely agree with what our colleague, Professor Mbote says. This really restricts the limits of the law, particularly in terms of bringing this kind of changes. I think that will be my contribution for the time being.
Thank you very much, Justice Minotti. We've heard your call for the paper to factor into consideration the original sentiments of opposition against the Constitution, the high turnover rate in Parliament, how this is a reflection of the issues at hand, and also the factors which are militating against the judiciary in enforcing the Constitution. He also recommends that we do not rule out the mechanism of amendments. So thank you for those views. We will now move on to Dr. Tom Daly for his views, please. Thank you.
Thank you. Yeah. So my comments are really going to build on what's just been said in many ways. And one of the first things I just wanted to pick up on was just that idea of hybridity itself, because I think it's so important that, Duncan, you're writing about a hybrid context, when one of the biggest sort of trends in governance worldwide is that the number of hybrid states, hybrid regimes, is growing. The number of liberal democracies and hard authoritarian states is actually shrinking. So this is a sort of a big, widening gray area that we need to understand. And we have a decent understanding of stable hybrid regimes like Singapore. We have a decent understanding of liberal democracies that have backslid into being a hybrid regime like Hungary. But we have a less well sort of nuanced understanding of post-colonial states that have sort of a very non-linear trajectory, where there's been oscillation backwards and forwards, where there have been democratic openings and dashed hopes repeatedly in some senses. And to a certain extent, reading your account reminded me a lot of Sri Lanka, and I've been working increasingly on Sri Lanka in recent years, where you get that post-independence opening, and it looks like you're moving towards a design of a parliamentary democracy that's liberal democratic in tone. And then you get a shift to presidentialism, strong presidentialism, a concentration of power, and then more fully authoritarian rule. And then a movement out of that to try and sort of move back towards a more democratic form of government. But it doesn't reach that sort of destination point. And I think what's really useful about this account is that it does complicate but also enrich our understandings, and moving away from these sort of preset teleological notions of what democratic transition means and what its endpoint might be. And I think, reading the account as well was really interesting for me, coming from another post-colonial state, Ireland, that, post-colonial states are not, it's not like other forms of undemocratic governance, like a military dictatorship or like the totalitarian communist regime, which leave very strong traces in the political culture and political system, but they do leave strong traces all the same. And it seemed to me that Kenya has both legacies at the same time. You have the colonial legacy, and then you have the authoritarian legacy as well. So it's a very challenging context. But with that said, I wanted to pick up on the discussion of the role of the courts, because a core strain in my work has been courts' democracy building roles in younger transitional democracies, especially more clear rupture scenarios where you have a clear shift to a democratic transition with liberal democracy as the clear stated endpoint. And I've talked about the role of the courts and constitutions more broadly in those contexts of being not just about entrenching the new constitution, but disentrenching the old constitution. And that works on both the the formal level in terms of getting rid of old laws and so on, but also the informal level, trying to push back against entrenched modalities of governance that persist despite the shift to a new constitutional text. So I've described democratization jurisprudence, as I call it, as involving 8 core strains of activity. So first dimension is facilitating the creation of a democratic public sphere. So I see 3 dimensions there as upholding core democratic rights, shaping an inclusive electoral system, and curbing the reemergence of authoritarianism. The second dimension is mediating the shift from an undemocratic to a democratic order. So 3 subdimensions there are articulating the relationship between the old and new constitutional order, addressing or eliminating authoritarian legislation, and addressing key transitional justice questions. And the third dimension is carving out a role for the court itself in the new democratic order. So you have delineating the court's jurisdiction and then addressing specific crises that may affect either the political system or the court more specifically. So it seemed to me that despite the fact that you make it very clear that this is not a rupture scenario, it seems to me that reading the account, the Supreme Court is doing a lot of this. But it was I was very alive to your frustration with courts in the text. So very much like the other speakers have noticed. So their inclination to run away from mega politics, you talk about their timidity and incoherence regarding electoral integrity, but then their occasional boldness regarding issues like separation of powers, when we think of the Constituency Development Fund decision, or on rights with criminalization of HIV transmission. And to me, it seemed like that frustration must be even more acute when you're dealing with a transformational constitutional text that sets out a very thick conception of democracy that goes far beyond even sort of your traditional liberal democratic constitution. So even, you know, the references to human dignity, equity, social justice, inclusiveness, equality, human rights, non-discrimination and protection of the marginalized. And then on top of that, you have provisions like Article 259 stating that the Constitution should be interpreted in a manner that advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights and contributes to good governance. So it's a very high bar to meet when you look at it from that perspective. But I think a few points could usefully be made here from a comparative perspective. The first is that, you know, most courts' case law in transitional contexts contain what Wojciech Sadurski, the Polish scholar, calls a mixed bag of undoubtedly courageous and democracy-strengthening decisions, as well as decisions which seem like a setback to these values. So I've studied the Brazilian Supreme Court in depth after the democratic transition in the mid-1980s, and you know, that also featured a much more ambitious transformational constitution, and it's true that you get this mix. So, you know, you get these decisions that constrain excessive lawmaking by the president, strongly vindicate the right to protest, for example, but then you also get other decisions that made it more difficult to challenge authoritarian era laws directly before the Supreme Court, that struck down the establishment of electoral thresholds, for example, aimed at bringing some order to the chaotic political party system, where you had 30 political parties and that they were trying to winnow it down a bit. So at the most basic for me, that simply reflects that you're dealing with a human institution that isn't going to always get it right. And it raises the question of how we judge courts and what success looks like. You know, is it the outcome that we want to see, or is it the coherence of their reasoning? And are we more forgiving of poor reasoning when we like the outcome? So if I have a few minutes left, I just want to say very quickly, we can look at this also from the perspective of judicial strategy. So when I was reading the section on the courts, I was really put in mind of a forthcoming article, it's not published yet, by Julius Yam, a scholar from Hong Kong, on how courts in the hybrid context of Hong Kong face this legitimacy paradox. So if they're too activist, they risk attracting backlash from the government, and that might be much sharper than what you would find in a fully liberal democratic regime. But on the flip side, if you're a uniformly deferential court, you'll undermine public trust. So Yam says that the courts in Hong Kong have navigated the hybrid context through three strategic adjudicative approaches. The first is differential treatment of cases according to the political stakes. The second is using comparative jurisprudence, and the third is commitment to procedural justice. Now, I'm just going to say a few bits about political stakes, because I think that's the most salient to your paper. So in 1999, for example, you have the Court of Final Appeal reversing a lower court ruling that desecrating the Chinese national flag was constitutional due to the high stakes involved. Similarly, in 2014, the court refused a petition seeking to find the president of the Legislative Assembly's move to remove the opposition filibuster in contravention of the basic law. So they upheld it as constitutional on the basis that it was not the business of the courts to determine the regularity of the internal processes of the legislature. So clearly there were huge issues involved there of megapolitics in terms of the interface with China itself. But then you get these other cases, which Yam calls medium stakes cases. So not high stakes, but medium stakes, where the court takes a much bolder stance on rights grounds. So in 2006, for example, it declared statutory surveillance powers to be unconstitutional in a case taken by an opposition MP and political activist. So Yam portrays this as it's the court's way of calibrating its interventions based on what seems politically possible, you know, which means that following principle is sometimes contingent. And when you look at it that way, a lack of principle can be viewed as shrewdness or at least a necessary instinct for self-preservation. And I was really interested in what Mark said about, you know, sort of building political capital so that you sort of can live to fight another day. And I think that certainly is a useful way of looking at the pattern that Duncan talks about. I also completely agree with the view that, you know, that younger courts are in a much more difficult position. They're building themselves at the same time as they're trying to build the new constitution and help along the new democratic dispensation. And even with longer established courts, you know, when they're under political pressure, and a lot of political pressure, you know, I worked with Turkish judges for 6 months from 2016 to 2017, and I saw up close and personal, you know, just the sheer pressure they were under to avoid a misstep. And that really does affect their jurisprudence and adjudication. But I've also said in my past work that this sort of delicate balancing and fudging can only be pushed so far. And for me, when it comes to central issues like electoral integrity, there's an argument to be made that principles should be strictly followed. Now, that's definitely open to contestation, but I'm very sympathetic to your views of the electoral integrity cases in that sense, Duncan. My very final comment is just really, sometimes I think when we're focused so much on the courts, we might miss out what actually other areas constitutional law should be focusing on. And one of the key issues from what I could see from this account is the party political system. You know, are there constitutional or legal devices that could help to stabilize the party system? So I was struck by the sheer, you know, just fluidity of the party political system in Kenya, and the sheer number of parties. So you say there's 78 registered parties in 2019. So I think, you know, we need to have a more balanced account of not only what the courts can achieve, but what are the other main issues that constitutional law could address. But I really enjoyed reading it. So thank you so much, Duncan.
Thank you very much, Professor Daly. That was a great comparative perspective, and thank you for sharing the Gaelic perspective as well. You've pointed out that there is no specific point of blame, that it's a multifaceted issue, which has translated into this pattern of a hybrid constitution. Nonetheless, you acknowledge several specific recommendations which we can look into. So thank you for that. It's a lot to digest. We appreciate your perspective. It is now my pleasure to introduce Professor Patricia Mbote. Please, may you give us your perspective.
Okay. Thank you very much, and thank you, Duncan, for a very good presentation. I enjoyed reading the paper, and I think it helped me also begin to appreciate some of the struggles we've had transiting fully to a democratic constitutional space. And as I read the history and I began to reflect on what we're going through now, the experiences that we have with the 2010 Constitution, I began to see uncanny resemblances between what happened between 1964 and 1969 and what we've seen happen particularly in the last 2 or 3 years, when people who had really resisted the Constitution begin to come out now with new gabs and begin to talk about the need to amend the Constitution. And you're looking at why are we amending the Constitution? And really, there is not a clear reason other than to expand spaces for different actors to get accommodated. And in essence, then, I've asked myself whether Constitution as a formal document is something that we own as Kenyans. Maybe we have very widespread acceptance of non-democratic informal notions, which are very deep-seated, And formal constitutional norms really have no chance in court when they face those very deep-seated non-democratic notions. What am I talking about? I'm talking about, for instance, the big man syndrome. And a big man syndrome that seems to sway people's notions of what is right and what is wrong. And when they bring in the informal norms, informal actors, structures, and interests, the Constitution seems to take a back seat. And if you look at the current discussions that we're having now on BBI, don't you marvel at what structures and actors are being put out against a very long argued, long thought out constitution. And in fact, even when we talk about deep state, that is probably, it aligns with the people who've been in government a long time, who may not really be in power, but are actually part of the bureaucracy that keeps those in power working. So in essence then, and this is from the previous point that we may have acceptance of non-democratic informal notions, constitutions as formal documents must be seen against what people see constitutions as way of doing things, utility of documents to enable people to achieve certain ends. So we then look at the tenets in the document itself, the spirit that we see in the document, but also we look at constitutions as living law. And living law that we see as needing to change as circumstances change. The only problem is there are certain key drivers of that particular change. And I'd like then next to just look at foundational issues that I see as glossing over even when we talk about constitutions. I think that one of the key things is belonging, citizenship. When we talk in the Constitution about being a citizen, are we citizens of the national polity Kenya, or are we citizens of our tribal cocoons? And you see our tribal cocoons come with their norms, actors, structures, and interests. And I think when we look at that notion of citizenship that is not national, it really does threaten the operation of a constitution, because a constitution is operative at the national level. And aligned to that is the whole question of land. Land and the link of, between land and citizenship. And I think the 2010 Constitution was very radical in the way it looked at land. But we also know, because political power, patrimonialism, all these have linked land to the people in power. That means that however much you want to change land relations, you can't change them as long as you don't change those in power. And so you hold those at the same place. And linked to land and citizenship is the contested identities, the whole question of marginal communities who are not seen to exist, and the Constitution brings them to the fore, but people still contend that they don't exist. And of course, they are also marginalized entities and groups like persons with disabilities, gender. And if you look at the discussions we are now having on division of revenue or whether to implement the 2/3 gender rule, you begin to see the contestation of the citizenship of certain groups. And this is because the formal document is, it's actually laced with notions of what is acceptable and what is not acceptable. And when people then get to the table to change constitutional tenets, they are thinking about things that are not really in the document itself. I would also like to put out when you talk about endogenous actors, I'd like us to problematize that within a global community, because we are no longer isolated from what's happening elsewhere. So what we may think as coming from within Kenya may actually be influenced by a lot of other interests outside of Kenya. And I don't want to belabor the issue of courts, but I think the whole question of the role of courts in forcing a move from authoritarian to democratic, to a democratic state, that cannot be really understated, because courts can actually cause systems to move. But that is when there is adherence to the rule of law and obedience of court orders. When we have disobedience of court orders, and we have courts being cowed by being denied resources, then there's a sense in which we may be expecting courts to do what they cannot do because they don't have the wherewithal to do that. Thank you.
Thank you very much, Professor Kameri Mbote. You've pointed out the deep-seated non-democratic notions that we have, which are militating against our realization of the spirit of the Constitution. You've also pointed out the very practical issue of the question of resources. It's easy to live in an ideal world, but sometimes it boils down to the availability of resources. You've also highlighted the importance of factoring the outside actors, which are having an influence on our situation here in Kenya. Thank you very much. And now we shall move on to Professor Ginsberg to please hear your perspective on the paper. Thank you.
Thank you very much. And thank you, Duncan, for this wonderful paper. It's really great. And I think you're going to be a real star in our comparative constitutional world with this kind of work. I wanted to say that, I think you're touching on a point which is now being recognized a little bit in the broader literature on democratization. So at the beginning of the third wave, there was kind of a teleological assumption that there was going to be transitions and all systems would move to democracy, or they would just stay authoritarian. And of course, what we've seen is that that's not the case. Sometimes this is talked about in terms of stalled transition, but maybe that's not the right paradigm at all. Maybe that there's no, that where you are is the endpoint, and these kind of hybrid systems are equilibria. They're, the natural state of politics in many countries. And so I think if you look at the factors which predict that kind of outcome, the critical thing is the importance of the old elites and the old parties. So, again, we think, oh, there's some old authoritarian group and then there's democratization and those people disappear. In fact, what we observe in a lot of countries is parties and networks transforming their power into a democratic period. Because they're powerful structures, and sometimes they have very clever actors. And that's how I read your description of Kenya, that you have this old, set of small number of families, big landowners, a party structure, which was able to basically retain its power. And, we have some other examples. I think of ZANU-PF in Zimbabwe and how they've managed to navigate and survive various challenges. In my part of the world, in East Asia, we have the Kuomintang in Taiwan and other parties which managed to really retain a lot of power despite or perhaps even because of democratization. So I think that's an important point. Now, that's important for understanding the role of the courts from my perspective, because, I kind of have this theory that you only get powerful courts when you have competing parties that see themselves out of power in the future. That's why they delegate a big space for courts to provide, political insurance or provide some kind of guarantee of their fundamental interests. And the fact is, if you haven't had the elite change and there's no prospect of it, there's no real reason we would expect to see powerful courts, despite the nice words on paper, and despite the actually pretty impressive quality of the judges in Kenya. I mean, it's a pretty smart group of people, but they're sort of structurally constrained from my point of view because of this, this deeper political structure. Now, one of the reasons the political structure hasn't changed, it's been brought up already by Professor Mbote, by Justice Mbote, that there's, the real deep economic structure hasn't changed. And that's therefore means that, it's easy for the sort of the structures of co-optation, the structures which undermine ideas of citizenship to, they just persist. And there hasn't been a radical break, and it's unlikely there's going to be such a radical break. And it's even hard to imagine what it would look like, how do you have a land reform in a very ethnically divided country that doesn't go badly awry? And so there has to be ways, of sort of moderate ways of trying to tackle that, but it's hard to see where it goes. So that's all to say that I think this might be a stable position where we're at. Now, where did the 2010 Constitution, I've been, by the way, to Kenya several times, not in 4 or 5 years, but I've been, really interested in the case, in part because we had this really open, inclusive drafting process. And that touches on a comparative set of issues that comparativists, like some of the foreigners on this call, we like to follow this. What's the role of inclusive constitution making? Is that a way to break open these economic structures, these political structures, and get a better, outcome? And that's what the literature sort of argues. Yes, we need an inclusive process. Now, I think the Kenyan case is really important for going back and examining that. And one way to read it is, yes, there was an inclusive process. There was ideas from civil society. But at the end of the day, think back to 2009. And what were the issues that were going on then in those discussions? What were the things which people brought up about the Constitution? They were, there was some discussion of land, but there was a lot, and county government devolution. But there was a lot of discussion about issues which, looking back, don't seem to have been very central to where we are. And I'm thinking about the Qadi courts issue, the issue about abortion, that almost derailed the whole Constitution. And I guess my suggestion is that public participation is not a panacea. It can be good. It almost derailed the passage of this Constitution. And the issues that the public focuses on are not necessarily the critical ones for governance. That's really the point. And so that also suggests that, there's not that much that could have been done given this maintenance of the economic structure. Now, I want to make 2 comments and then raise 2 questions. So the comments, despite everything that has been said, actually, let me start with 1 comment and 3 questions. So the 1 comment is about the international community. So the international community, I agree, has interests and wanted, maybe helps to perpetuate some of the maintenance of these deep structures in Kenya. On the other hand, the international community also, plays a moderating influence on the other side. And I think that's a point that you could mention in the paper, that it not only prevents, in your view, I guess, sort of further democratization, but it also prevents further autocratization. And that, of course, was the whole point of the Kofi Annan intervention, that the international community cares about Kenya because it's a very important country. And so that's going to limit sort of how far you can move in either direction, both for good and for bad. The questions. You make a big deal about the maintenance of ethnic politics, and it sort of illustrates that constitutions, and this happens throughout Africa, there's a lot of countries which have ethnic party bans on mobilizing parties around ethnicity, and those don't really, let's be honest, they just don't work because ethnicity is the basis of mobilization, so it's very hard to sort of legislate it out of existence. But is it not the case that one virtue of this particular constitutional structure is that we have seen some rotation? And I know that there's been no rotation at the presidency, but I know that looking ahead to 2022, and this is an outsider and I don't follow the day-to-day, but there has been a little bit of shuffling of the decks within the elite, right? And if that's so, if the coalitions actually could vary across all the major groups in the society, then that would be the basis for you know, a lot of good things about governance, because it could create that kind of demand for insurance. Yes, I'm out of power today, but I know I will be in tomorrow. Or I'm in power today, but I might be out tomorrow. So I want to make sure that whoever's in power can't have everything, can't eat everything. So that might be, the rotation is good. And is it really, you know, impossible that 2022 might see some rotation on the ethnic dimension? Second question. The judiciary. So we've been talking about the judiciary as sort of a whole, all of us, the commentators here. But I would like to know more. I think it's a very interesting question about the Kenyan judiciary, about the internal structure of it and how it interacts with this deeper, very corrupt political system. And of course, you talk a bit about the cases of corruption, but inside the judiciary, there seem to be politics between the Court of Appeal and the Supreme Court, High Court as well. Are there networks within the judiciary that organize the justices? And I know it's a sensitive question, but I guess I think someone should study that. I think it would be very interesting to really understand how the judiciary is internally structured. Because if the judiciary was truly united and truly unified, I think it would be a more powerful force. Then, you know, the outside politics and the money politics couldn't, you know, pick people off for their own interests. So a question about internal organization of the judiciary. Final question about amendment. So, and it's just a very small question, but you said, interestingly, I never heard this before, that one of the reasons that the amendments, you know, have kind of stalled is because of the 90-day reading period. And I was very interested in that. I mean, what is it about the 90-day reading period? Is it the idea that the coalitions are really unstable inside the parliament, so that when someone proposes an amendment, good or bad, it gets undermined in the 90 days, or the other forces pay off the proposer? I think that's pretty interesting observation, that just the fact that multiple readings could derail an amendment, it suggests a very unstable politics, a kaleidoscope in which you know, the things are always shifting and there's no real stable basis of interest other than everyone in the parliament eating as much as they can, which we do know about Kenya. So fine, that's what I have to say, and thank you again for the opportunity to read this.
Thank you very much, Professor Ginsburg. Those are great questions, and some members of our audience have echoed those questions. So before we get to our final commentary, which will be from Professor Theunis Roux, who's a professor of law at the University of New South Wales in Australia, and who's supervising the PhD thesis, I am going to ask Duncan to respond to those three questions, and feel free to call on any of your co-panelists to give their perspective. And then we will have the final commentary from your supervisor, as well as fielding any further remarks that come in from attendees. Thank you.
I think I'll first of all request, thank you very much for the feedback. I'm here with the president, and we are nodding at each and every sentiment. We are in agreement about many things, quite dense information that needs to be unpackaged, I think, over a long period of time. And I think I have a richer book project than I initially thought. I thought I would have a book with 9 or 10 chapters, but it seems to me that I need to make an encyclopedia of a sort on Kenyan politics and constitution. But having said that, I would like to ask Judge Kathurima perhaps to answer question number 2 on the working between, you know, the different superior courts, and how that impacts, in a way, the success of the courts.
Yeah, thank you, Duncan. I think the judiciary in Kenya is a reflection of the Kenyan society. Yeah? You have a mixed crew of judges. Some are very conservative, others are very activists, others are very cautious, you have this mixed grill of judges. Some have different views, others have this kind of view, and others completely the opposite. And I think this is really what is that has to be expected. There have been situations where, of course, those differences appear to spill outside the judiciary, which really ought not to be the case, because judges within each level of the court ought to be guided really by the law. You take a position. If another judge does not agree, you have a dissenting judgment, and you have a way of going all the way to the final court. So just like you find in very many other courts, you will find a situation where the High Court, for example, as the first trial court, takes a position, the Court of Appeal takes a different position, and the Supreme Court agrees with either of those two courts. So in terms of differences of opinion, I think it's very rivalry in quite a number of situations. Although really, as again Duncan has noted in his presentations, there have been situations where we've had judgments where you are not very sure really whether the judgment is being guided by the law or whether it's by considerations outside the law. And to me, that is the real challenge. In terms of organization, really, each and every judge is supposed to be independent, in terms of being able to express themselves and the positions that they have taken in each and every judgment, and nobody can be penalized really for holding a particular view. Yeah. So to me, it's not such a big challenge, only that, as you find in very many other judiciaries, you'll have conservative judges, the others that are very activists, the others who are very cautious. When you try to look at a problem and see its political implications, you'll have some who don't, as far as they are concerned, what matters is the facts, the law. You damn the consequences. The others who want to look and say, what is going to happen? If you make this kind of decision, is it going to completely destroy the judiciary and make it completely impossible for it to do some work? So those considerations, I think you will find them in each and every judiciary, and Kenya is not the exception. There is a point that was made about the judiciary and the constitution, about 10 years old. I think there are so many things that are yet to settle in terms of being able to say with certainty what kind of judiciary we have. I think that's what I would say. Duncan?
I just want to answer a question that was asked by Professor Ginsburg about the magic with the 90 days. And I think what happens when you look at the amendment history of Kenya, particularly in the 1960s, there was an amendment that could be proposed in the morning. It's actually passed in the afternoon. And I read a paper of Kenyan scholar H.W. Okoth Ogendo on constitutional amendments in Kenya, where he suggested that an amendment, for instance, to abolish Senate was proposed, discussed, and passed within 45 minutes only. And so somehow the drafters of the Kenyan 2010 constitution decided that once you introduce a bill in parliament, you will have to give it a second reading after 90 days. And this provision, I think, has done magic in a sense, because an amendment is proposed, then something comes up between the day when it's proposed, the politics shift to something different. Somebody just abandons it there. One of them will, for example, be a provision, somebody sought an amendment to the constitution that the deputy president should be given powers to act as the president at a time when the Hague trials were ongoing. He made a proposal was made in parliament. The bill went for first reading. By the time the bill was going for the second reading, something had happened. The dates for hearing were not overlapping, as it were. and they just abandoned it. And that has happened for many of the bills that have been tabled in Parliament. So that the 90-day period, I think, creates some form of constitutional moment of a sort, and then there isn't sufficient momentum that is sustained over that period, over the issue. And the result is that that impetus to amend the constitution then dies. It just dies, and the idea is abandoned on the way. So I think that might have been the main contribution of this innovation, except that, and I discussed this last week in some forum, that the challenge with rigidity of the constitution as a benefit that we have is that then the executive or anyone decides to venture into informal constitutional change. And that's what Judge Kathurima is saying, that look, we have a constitution which says there shall be a judiciary fund and you're going to devote this, it should help in this. Political elites in the 1960s will simply say, no, we can't comply with this, it's too complex for us, let's pass an amendment and we see how to undo it. In the present times, it becomes impossible because you need 90 days and a budget cycle will be coming. So what they do is they say, okay, let's just not give the money, and it serves the same purpose, except that they do not pursue any form of legality over the issue. So I think that the challenge or the danger that has come with imposition of constraints on amendment of the constitution is simply that it has become difficult to pursue the formal amendment process, with the results that now political elites are making good use of informal constitutional change. I can't, on your first question, I can't really foretell what will come up in 2022, whether there might be shift of power and whether the ethnic orientations will change. I know you have been studying Kenyan politics quite closely. But my main concern when I was writing the thesis, and maybe I should say this, is that I examined in part whether ethnic cleavages or identitarian practices, inclinations in politics, can actually stand in the way of democratic reform and consolidation. And I take a skeptic view about it, because when you look at a country like South Africa, you will see there are racial divides, which are really pronounced. If you look at Benin, there is a north-south divide. Perhaps the only country in Africa that can be said to be fairly homogeneous is Cape Verde, which is also a democracy. So that even with the existence of ethnic cleavages and their influence on politics, it would seem that it's a condition that obtains in other countries that have been able to transform into democracies. So that for me, I wouldn't think that it is something that we should cite as the main reason why we are not able, for instance, to implement the constitution or to realize democracy or real constitutional change, as I call it. But yes, of course, we also must admit that something like ethnic mobilization of politics seems to be out of the reach of the constitution, that no amount of constitutional design can make individuals to say, now we will vote on the basis of values. We will not vote on the basis of identity. This is something perhaps that tells us that maybe we may need to have little faith in what our constitution can do to us in shaping our politics. I think that would be my comment on your question, Professor Ginsburg. Back to Valentine.
Thank you very much, Mr. Okubaso. On the question of amendments, this question has been fielded a couple times on the forum. So I was wondering, Professor Ginsberg, would you like to say a comment on that? On the pros and cons of amendment?
Well, I mean, as a general matter, of course, all constitutions, you know, need to be amended and need to be changed over time. And of course, now 10 years of experience in living under this one, I think the country has learned something, right? The people have learned something about what they like and what they don't. You know, I've been in other countries part of processes where at this time, there might be like a review, a comprehensive review. I know the African Network of Constitutional Lawyers just ran a program on this, reviewing the Constitution at 10 and just making an evaluation, a technocratic, you know, technical evaluation with, you know, what's good, what's bad, what might we propose in it. To have a body responsible to the public for the implementation. I thought that was a great innovation. I think there's some other innovations in there too. And so even though it's, I guess my point is you can't help but use this international idiom, but there's still ways to tailor it to the local situation. And that's a question of how well it's done that I can't answer.
Thank you very much, Professor. Before we move on to the last commentary from each one of the panelists, as well as from Mr. Okubasu himself, I'd like to call upon Professor Theunis Roux, the supervisor of the thesis, to please give us your perspective and views. Thank you.
Okay, thanks very much. Thanks for having me, and thanks for hosting this event. As one of Duncan's co-supervisors, I'm very grateful for this opportunity to listen to all of your inputs. The other co-supervisor is Philip Langbroek at University of Utrecht. As co-supervisor, my role here is obviously not to comment directly on Duncan's work. That is something that I do in private with him. But perhaps I can do two things. I can say something very briefly about the nature of the project. So put this chapter on Kenya in context a little bit, and then offer my reflections on what I think Duncan has learned or should learn from the various comments that have been made. So first, very briefly, Duncan's project, it is a comparative project. So he's looking not just at Kenya, but also at Benin and Cameroon. And he's chosen those three case studies because of their different transitional outcomes being representative of his three types. So Benin, until recently, a fairly solid example of a constitutional democracy, Cameroon of an authoritarian regime, and Kenya of a hybrid regime. And what he then did was inductively, with his knowledge of those countries, isolate different variables that he thought might have had some causal role in their transitional outcomes. And then he's systematically comparing those variables across the three countries. And those are broadly actor-based variables and structural variables. So that explains the structure of the chapter that you've just seen Duncan present on. That's why he's looking at the judiciary, why he's looking at the formal constitution, why he's looking at the role of civil society. Those variables have all been identified in the context of a comparative study. And he's then got a so-called medium end chapter where he takes a number of other countries, and he's really just trying to identify necessary and sufficient conditions of the changes that he's interested in. So perhaps that helps to put things in perspective a little bit. He's not in this Kenya chapter trying to explain everything. The Kenya chapter is simply playing a role in a broader comparative project. So the real findings and the real lessons of this PhD are going to come out at the end, once all of those variables have been isolated and compared. Which is not to say, of course, that a case study shouldn't hold up in its own right. And I think this session has been really valuable in testing the basic lines of explanations in the case study chapter. Then as far as what Duncan, I think, can take away from this session, at the risk of being a little bit too clever and tricksy-dixy, we could summarize it as saying that the discussion has revealed the 3 C's that matter to some extent, but the 4 I's that matter more. So what we said is that constitutions, and the constitutional text in particular, matters to some extent. So out of the discussion has come empirical observations about resistance to the 2010 reforms. That wouldn't have happened if constitutions don't matter at all. There was a mention also of an attention to constitutional amendments immediately after independence. That wouldn't have happened if constitutions didn't matter at all. So clearly the form of a constitution matters to some extent. But the really big lesson is that from the point of view of incumbent power holders, it proves easier to resist the implementation of a formal constitution than it does to resist the adoption of a liberal democratic constitution. And that difference between the ease of resistance to implementation as opposed to ease of resistance of adoption has something to do with the other I's that we will come to in a moment. The second C is obviously civil society. We've seen that civil society matters to a certain extent. It can drive a transition to a democratic constitution, to the adoption of a formally democratic constitution, but thereafter we've had observations about co-optation of civil society actors in parliament. And third, C, courts. Courts matter to a certain extent. They can intervene to prevent backsliding, but they don't appear to be able to change the overall trajectory of transition. So the 3 C's that matter to some extent, the 4 I's that matter more, informal norms, whether these be norms inherited from the colonial state, norms inherited from earlier authoritarian periods. I think it's best encapsulated in the comment about the big man syndrome. The second I is either interests or incumbent power holders, which feature in Duncan's story and in the comments in various ways as resistant to change. The third I, international actors. I think Tom Ginsburg's comments here were most instructive in the way that they've been a real force for stabilizing this hybrid equilibrium, preventing both the backsliding towards authoritarianism, but also real progression towards democracy. And then the fourth and final I being, of course, identity, ethnicity and tribal identity coming through. So if one left it at that, one would end on a pessimistic conclusion that the power of the I's overwhelms the moderate influence of the C's. But I did see some optimism, particularly in Tom's comments about identity politics and dispersion, the possible political diffusion that might very well flow from the fact of ethnically mobilized political parties. So I think in any polity, there's always that prospect of change, but it has to be a change that is driven by the structural conditions of the country rather than by the interventions of individual institutional actors on their own. So thanks very much, everyone, for your comments. We've learned a lot, and I'm sure Duncan will take this all to heart.
Thank you very much, Professor Roux. We agree that indeed the paper has prodded our thinking, and we certainly look forward to the final product, its findings, as well as more lessons and best practices on the way forward. So with that, I'm going to ask if Professor Mbote can please give us her final views on the paper. Oh, okay, she seems not to be available. If I could ask, oh, sorry.
I am.
Oh, okay, you are. Thank you.
Yeah.
Thank you.
I'd just like to thank Duncan for the paper and to tell him that I'm looking forward to seeing the final work. I think you've got a lot to chew on, but we are looking forward to seeing the whole picture, as it were, because we've now had a sliced view of the Kenyan bit. Thank you.
Thank you very much, Professor. I'll now like to call on Professor Mark Tushnet to please give us his parting shots. Thank you.
Thank you. So I have found this an extremely informative conversation, and I've learned a great deal about the Kenyan situation. I think I want to echo one of Tom Ginsberg's remarks, which is that it's probably important to start from an analytic point of view rather than a normative one, thinking about stabilized hybrid constitutional regimes. We know that the political scientists invented the idea of hybrid regimes to avoid the implications of language like transitional and the like. I think we in the field of comparative constitutional law have sort of embedded in the field a normative position such that something like the very idea of authoritarian constitutionalism or hybrid constitutional regimes as a type is problematic. But I think what we want to do is perhaps explore the conditions under which hybrid regimes are stabilized, and the discussion of endogenous sources and exogenous constraints seems to me extremely valuable. Thank you.
Thank you very much, Professor Tushnet. I'm now going to call on Honorable Justice Minotti. Please may you give us your final perspective. Thank you.
Yeah, thank you very much. I think for me, having lived through the periods, most of the period that we are talking about, I'm quite grateful to see a very cogent explanation as to why we've not been able to reach the Kenyan that we thought we would reach with the adoption of the new constitution. And then I would really like Duncan to consider more this issue about the role of the courts, which I think sometimes is overstated. There are so many limitations that are very, very, very obvious as to the ability of the courts to enable us to move to the desired position. Thank you.
Thank you very much, Justice. I'll now like to call on Professor Ginsberg to give us your final perspective, please.
Well, I have very little to add. It's been a wonderful session. I certainly learned a lot and look forward to the book. I think it's exactly the kind of work we need, comparative work within Africa to understand these different dynamics and trajectories. So congratulations so far and look forward to the final product.
Thank you very much. And now if we could please have Professor Daly, if you can give us your final perspective, recommendations, critique, please. Oh, sorry, Professor Daly, you're on mute. Sorry, we can't hear you. If you can unmute your, thank you. We still can't hear you.
Okay, there we go.
Now we can, thank you.
Sorry, I'm talking through my phone, so sometimes there's a little lag. But I just have one recommendation and one final comment. The recommendation is, I think you would get a lot from, if you haven't read it already, John Keane's new book on the new despotism, especially as regards how he treats the interaction between neo-patrimonialism and other aspects of governance, and precisely how he doesn't deal with it as an aspect of political underdevelopment, but actually an integral and complex feature of political development. The final comment is just, I think if you're looking at the international context, it might be useful to think as well about what is the regional context for democratization, because there is research out there that says if the regional context is very supportive of democratization, then that does have an impact. So South America and Central and Eastern Europe had sweeping region-wide democratization processes, and that's very different to the East African context, where it's much more diverse in terms of political systems. So whether that actually also has an impact as well might be worth just factoring in. But thank you so much. It was a really interesting chapter. I can't wait to see the full project.
Thank you very much, Professor Daly. So now I would like to go back to Duncan. We've really enjoyed this critical appreciation of a snippet of your final thesis. And we hope that the feedback, the questions from the audience and your peers has been helpful. We look forward to the final product. Is there anything else you'd like to say?
Maybe I can see this Judge Mativo that is following us, and he asked a question.
Sure.
Whether 10 years since the promulgation of the Constitution, I still think that the arms of government have played their role in implementing it. I think that the answer to this question lies in a presentation that I attended by Professor Tom Ginsberg on whether there have been sufficient incentives on the part of people who populate those institutions to implement the Constitution or to enforce it, as it were. I can't tell that the arms of government have implemented the Constitution, but as you can see from the discussion we had with Judge Kathurima here, it seems that because of the resistance to a democratic order, of course, a democratic order threatens the establishment of the day in a very great way. And so you can't just expose yourself to the vicissitudes of democratic politics. And one way to go about it is to ensure that you don't enforce the Constitution. Perhaps also that's where lies the issue about, how will courts, build up themselves to be effective in mega politics. So I think that, yes, the courts might have tried to implement the Constitution, but they are building themselves, and at the same time, they are trying to build a democratic order. And maybe it could be too harsh of me to say, look, that the judiciary has not tried to build up the Constitution or to push the country towards a democratic order. But having said that, it appears to me that the political elites, the political class that does not see itself in power, out of power, as Ginsburg suggested, is not keen really on ensuring that the gap between the text and the practice is closed up. And on a final note is that there's a pessimist view that I have, and it's a pity that after writing the project, I still think, like Professor Okoth Ogendo, that it might take more for African countries and political orders to transform into democratic countries. He said in his 1989 paper on constitutions without constitutionalism that they might be destined to pass through the transitions like the one that mature democracies have passed through. And if there is a stable hybrid status that is, stabilizing over time, perhaps then that there might just be change if there's a dramatic episode that takes place either deep political, social, and economic crisis that then makes it difficult to hold on to the practice that has found currency over the years. And maybe I think also is that they might need to take stock and account of the norms that have been generated from the pre-colonial, colonial, and even post-colonial periods. The norms might be undergirded by some understanding of how power is supposed to be used. And until and unless those are disestablished, that we might have a long way to go. I have taken note. My book is almost full of the comments and the sentiments that have come from the panelists. Quite dense comments, leaning towards the faith that I have or that I don't have towards the courts and what they can do. And I think that when the project has been completed, it will contribute to our understanding of the Kenyan society and also the African society. And with those remarks, I'm eternally grateful for these comments. My president is here, President Harvey. I would like him to say a word, and then I think we can end in just a minute or two. Please.
Thank you, Duncan. Thank you, the professors of law. This has been a very enlightening session. And on behalf of the political class, I would like to assure you that we want to work hand in hand with Duncan to ensure that Kenya realizes full democracy in order that the constitution that we fought so hard to promulgate on the 27th of August 2010 that does not continue to suffer in the minds of those who know or know little the rigidity that they claim necessitates the need for us to be a little bit more elastic and amend it. Yet in real fact, all we need to do right now is to implement it. I look forward to reading more of Duncan's work and also reviewing the great works that the professors of law have referred us to. On behalf of the Law Society of Kenya, may I thank you most sincerely for participating in this exercise and encourage you, as and when we call upon you to come and give us wisdom to accept our invitation. Be blessed.
Thank you very much. Thank you.
Thank you, everyone. And have a nice time. Thank you, Tom. Thank you, Judge. Thank you, Tom Ginsberg, Tom Daly, Mark Tushnet, Theunis. Thank you very much. And Valentine, thank you very much.
Thank you very much, Duncan. Thank you, Justice Minotti. Thank you, professors. Thank you to the Law Society and the attendees for attending. Thank you.
Thanks, Duncan.
Thanks, everyone.
Thank you.